Good morning, everybody, and thank you once again to the organizers for giving to me and my institution, the European Data Protection Supervisor, an independent institution in charge of monitoring processing of personal data by European Union institutions and bodies, but we are also an advisory body for the European legislature to be here today with you. Be relaxed, because I'm not going to be academic today. I would like just to build on the previous comments by Ambassador Manservisi to give you an update where we are today on data protection around the world. The White House has just released a 90-day study on big data, highlighting the high benefits we expect from this new revolution, but also, in addition to the opportunities, the increased risks for individuals, government, businesses, in terms of surveillance, discrimination, but also in terms of lack of trust. And rebuilding trust is the title of today's panel. 2.5 years after the European Commission launched the review of the European data protection legal framework on data protection, in Europe we are very close to approach a safe harbor, which means the final adoption of a package. We expect to see in the official journal by spring 2015 at the latest. And this is an important contribution to the debate around the world. I'm not here to appear as a data protection evangelist and to say data protection at any cost. I define and describe myself as a reasonable regulator. But I think that without a robust data protection, there are no chances. This is what I took the liberty to say with the trip this morning for a data-driven economy. So the European Parliament has passed in March this year a package composed by regulation and the directive. I think the same directive which relates to police and judicial cooperation is relevant for you, because there are a lot of provisions concerning obligations to providers, for instance in terms of mandatory data retention around data to be further processed for police and judicial purposes. It's perhaps the most important dossier of the last 10 years, as the heavy lobbying which surrounded it, around 4,000 amendments clearly show. The Council, because the European legislator is based on two pillars, Council and Parliament should be together on the text. We'll discuss this package early June, and we expect again at least a partial agreement. And then I'm proud to say that perhaps under the Italian presidency of the European Union in the second half of this year, we will be very close to the final plan. Why we discuss about data protection? Because it's important in front of big data phenomenon to discuss if such initiatives, including the bill on data protection we discussed about Turkey, are modern and flexible enough to cope with the challenges posed by big data. I was impressed about the supreme quality of certain analysis, and it seems to me a sort of a deja vu. It was me in 1995 doing the same exercise in my country, and then Italy has passed first law on data protection in 1996. And then I was thinking to the quality of certain analysis, but also on how these provisions should be global around the world. Big data is not only a data protection issue, but an analysis from a privacy and data protection viewpoint should not be marginalized. Big data will have a profound implication for our society. I'm not describing now what is big data. There are various definitions, but all of them, or most as you prefer, highlight the growing capability of new software, new hardware to capture, transfer, merge, and extrapolate potentially unlimited volumes of information in multiple ways faster than ever. So around the internet, we discussed for years and years about, the free flow of data, the interoperability of different systems, about internet governance, about data retention issues on WUIs. But now, big data is outside the door and is going to trigger new challenges, new discussions. It will become soon extremely difficult and perhaps impossible to process these new volumes of data by using standard management tools or by using traditional processing operations. So what is the right approach now to take from a data protection viewpoint? I'm not suggesting to resist to new technologies. Big data collection and analysis can undoubtedly, where used well, and I insist on this well, may improve our society. So prosperity, well-being, right to information. And therefore, we could analyze the increased risks for fundamental rights in individuals in a proactive way. In Europe, citizens, not only citizens, residents, will continue to theoretically benefit from a fundamental right, which is now in the treaty and also in the European Charter of Fundamental Rights. The right to be subject to processing of personal data only if this processing is fair, based on a legal basis, performed for a legitimate, specified, and transparent purpose. But the question is that social media, apps, apparently free online products and services are already designed, and this is the perspective for the future, to maximize as much as possible the collection of information to be analyzed, used as a mirror to attract investors, as well as to maximize a return on advertising. The recent G8's 2013 Open Data Charter highlights the principle of open data by default, what it means to make data more freely and open for a reuse. And finally, in the era of Internet of Things, our domestic devices, vehicles, sensors embedded through wearable techniques will reduce costs to collect, share, and store information. So again, we have a list of questions for today's debate. I'm not, occupying your role, Ben. The question is, are the rules we are discussing introducing at national or international level global, modern, and flexible enough, technology-proof enough to be effective and not to be obsolete soon? When I say flexible, I'm not suggesting to lower the safeguards. I'm thinking to general provisions, not entering into too much details. Another question is how much users and consumers will be capable to be informed on what others are doing about data. We speak about personal data. Who is the owner of the data if someone else is processing this information in a non-transparent manner? So how much citizens, users, consumers will be in control of the data they provide intentionally or inadvertently hundreds of times in multiple ways. So we should not be entirely skeptical about the future. This is not the first time we have a big revolution in terms of automation of data and systems. We tested around previous generations of data protection rules other challenges. For instance, when in the 70s we moved from manual to automated processing. I remember a discussion in France discussing about the Safari project, or in Australia, a lot of protests around the streets against the Australian citizen card. Then we had other challenges when we moved from analogic to digital networks, from the pioneering development of e-commerce to the information society, from the silos to the interconnected large-scale data system. So big data is new, but not entirely new. But of course, we will have, again, new high-performance computing, new sophisticated technologies. Databases will be able to create new patterns, new correlations, new relationships, and new results in an unprecedented way. And therefore, I think citizens will have a problem in being aware about the way in which this information will be analyzed and by using certain algorithms. And certain opportunities or risks for controllers, for data subjects, will be available immediately after the data fusion, not in another stage at home as a result of a long-term process in elaborating the information. I mean, in real time, instantly, after data is captured. It means that users and consumers will be soon overwhelmed by the increased level of sophistication, also by thinking to certain predictive and real-time large-scale software. So I'm sure you will agree on the need to have a reflection on how to reinforce existing safeguards against unjustified and unlawful profiling. I think you will agree about the need to discuss the notion of harm concerning users and consumers, but also the standard categories we use in data protection legislation. This morning we had a look to the notion of identifiability, when an individual is not directly identified, but could be identified by using reasonable means, and then you may discuss about, details. Our question is that the developments, the new computational capabilities, will allow, on the basis of unstructured loss of dispersed data sets or data amassed for different purposes in different contexts, entirely new results. So technologies aiming at re-identifying individuals will evolve constantly in real time. We will have a sort of mosaic and puzzle effect around information, even in cases where the controller was not oriented to identify individuals. Big data is not necessarily and not only personal information, but an increasingly larger part of information will relate to individual information. So other principles around the traditional data protection legislations will be affected. For instance, the notion of quality of data. When you use a big amount of information, big data, perhaps some of the information will not be necessarily reliable and accurate, and therefore trusted. What about risks for human error or interpretation? What about automatic decisions based on this information? What about the principles of need to know? I think you are aware of that principle. The purpose limitation principle, the data retention principle. And to conclude, what about the notion of data subject, the individual to whom the information may be related? In the area of genetic data, this notion is to be analyzed specifically, because you are also part of a group of relatives. And perhaps we are moving soon to a new notion, the notion of co-data subject. And that's a new challenge. The European Data Protection Supervisor has launched in Brussels a new debate. We adopted a preliminary opinion, which is available on our website, and we launched a big workshop at international level in Brussels to be held on the 2nd of June. You are all invited. We will publish the results, and we will continue the analysis with a second round of discussion in fall. So I'm not saying that the European legislator is introducing now rules to satisfy all these needs and answers. I think there is a lot of issues to be discussed. I think some ethical implications are also to be analyzed, and therefore it's important that what we call a third country, Turkey, we're approaching to new provisions, and as a reflection, not only by considering its own cultural traditions, but also by thinking in global terms. So thinking in global terms is today's challenge. Thank you for your attention.
Good morning. Slight change of pace now. You've all been sat there, very patient, being talked at by lots of people in suits and ties. This is your opportunity now to ask questions and to be part of the debate. We've got microphones, and they'll be moving around the room. If you don't join in, then you're going to have the embarrassing for us all spectacle of a group of people sitting up here slowly dying in front of your eyes, and we will end up discussing whether England's chances in the Ashes, whether we're going to retake the Ashes from Australia, a subject about which I can talk for many hours. So let's not go there. Before we start, it's quite an interesting topic. It says here, privacy and data protection, rebuilding trust. And there's quite a lot in that question. So I want to ask you, the audience, just a simple show of hands, a very simple question. Let's go back, I don't know, a year. I think a year would put us the other side of Snowden. So in that year that we've now had, just by show of hands, I'm going to ask you, who thinks that their trust in the internet, who thinks their trust in the internet has gone up? Who feels that they can trust their data, their personal information, their transactions, whatever? Who feels that that's gone up in that year? Who feels more happy about the internet? All right, well, that's pretty conclusive. Who feels that, you know what? You know, nothing much has changed. The internet was what it was. It is what it is. And nothing much has changed. So who's happy that it's about the same? One or a few. Okay. I'll come back to you in a minute. So does that mean, all right, let's do it. Who thinks that, oh my God, the internet, what a terrible place that is. It's all gone horribly wrong. I don't trust it at all. Okay. And then presumably everybody else is now, well, it's got a bit worse, but I'm pretty happy. Okay. No one thinks it's got better. Is interesting. And a lot of people think it's got a lot worse. So the last thing I'm going to get you to do, why has it got worse? Why? Just shout out. We don't have to do this with mics or anything. Just shout out some reasons that you think the internet has got worse. Just shout them out. Trust. Yeah? So what's caused your trust to go down in the internet? Okay.
Increase horrendously, and now we ask to trust, and everybody thinks about small instances. So
Okay?
And we talk about the...
So big data.
Yeah, okay, now we question.
That's okay. Do it very quickly.
So, of course, now we think about like the rainy days when we wash the car. So the idea, of course, there's a bias, and then we say we don't trust, but there are the data increase and the decrease in the trust. We have to talk about what the trust, what do you mean?
So big
trust
data.
of personality or trust for the government? Trust
Okay, that's exactly what we're going to do.
Trust for the food.
That's what we're going to talk about. So big data is one there. You mentioned the government. Any other, just shout out words, I don't care what they are. New applications. Anything else? Ads, thank you. Yeah, I'm making notes of these. Ads, apps. Anything else? Everyone's becoming a publisher. Yeah? So you could publish information about me that I don't know about? Yeah? Anything else? No? No one's mentioned the S word. No one's mentioned Mr. Snowden. Oh, Snowden, someone said. Excellent. Right. Plenty to get on with. What we're going to do now is I'm going to ask the panel to introduce themselves, and then very briefly, in that introduction, they're going to lay out what they think, their beliefs, their stand on the whole question of privacy and trust. If you want to start here, Bill.
To speak.
Yeah, oh.
Thank you very much. I'm Evin Başak from ELİG University, and I'm an assistant professor working in the areas of civil law and data protection. And my point of view regarding data protection in this age is that we are still in the kind of stone age in the digital area. So we have to develop. We have to work on our principles, and we have to somehow adapt the needs of our environment into the data protection rules also. So we cannot improve theoretical concepts and try to put them on the internet. There is a lively developing area, and we have to adapt our solutions to our we have to adapt our solutions and create the right principles in order to find solutions regarding data protection problems.
Excellent. Thank you. Thank you very much.
İsmim Mustafa Taşkın. Adalet Bakanlığı'ndan aramızdayım. Adalet Bakanlığı hükümetiyle bulunuyorum burada. Az sonra kişisel verilerin korunmasına yönelik tasarıyla ilgili bilgiler arz edeceğiz. Verilerin korunması konusunun önemi artık günümüzde tartışmasız. Daha önceden biz hep şöyle derdik, fen bilimleri evrenseldir ama sosyal bilimler görecelidir. Genel özelliği vardır derdik. Bir insanın kalp atışı veya kan dolaşımı Hindistan'da neyse Amerika'da da aynıdır. Ancak hukuk kuralları bakımından görecelilik ve yerellik daha ön plandaydı. Ama günümüzde toplulukların artması, birliklerin artmasıyla beraber hukuk kuralları bakımından da evrenselliğe doğru çok ciddi bir gidiş var. Bu gidişin içerisinde veri koruma da tamamen internetle beraber, iletişim teknolojilerindeki gelişmelerle beraber evrensel bir olgu haline geldi. Ülkemiz bakımından da son derece ciddi sıkıntıların, sorunların yaşandığı bir alan. Taraf olduğumuz Avrupa İnsan Hakları Sözleşmesi ve yine yargılama yetkisini kabul ettiğimiz Avrupa İnsan Hakları Mahkemesi iştahatlarına baktığımızda, yine anayasamızda yer alan ilkelere baktığımızda özel hayatımızı mutlak surette korumamız ve güvence altına almamız gerekiyor. Ve devletin bu anlamda pozitif yükümlülükleri öngörülmüş. Bütün bu anlatılanlar çerçevesinde internet ve veri korumayla birlikte özel hayatın korunması alanında yapılacak, Nilgün Hanım'ın da bahsettiği gibi çok şeyler var. Ülkemiz açısından çok şeyler var. Avrupa ülkelerine baktığımızda 30 yıldan beri, neredeyse 30 küsür yıldan beri bu alanla ilgili kafa yorup çalışmalar yapılıyor, ilkeler ortaya konuluyor. Ama ülkemizde hala bu konuda sağlam bir dayanak olacak, referans olacak metin henüz ortaya koyamadık. Alacağımız çok yol var diyorum ve noktalıyorum.
Gonenc Gurkaynak. I'm an attorney at law, and I'm also an academician. I have been teaching internet law for about 10 years now at different universities, and I'm also representing very many internet companies, and therefore I have to come up with a disclaimer first. Because I'm the Turkish attorney on all of their legal matter for Google and also for Twitter. I'm not talking on their behalf. This is not rehearsed with them, and I'm speaking as an academician that believes in certain concepts. I think the first thing that needs to be discussed is whether we are being divided into camps in internet law in general. Camps as data privacy people versus freedom of speech people. It is very alarming to me, again, to see today that no one has said anything about freedom of speech. And so far, data privacy issues have been discussed as if these are completely independent from issues of the right to know, freedom of speech. Something that I find missing also in the European Court of Justice's last decision. I would not say that this diminishes the value of data protection and data privacy. I would, in fact, make a case that data privacy and data protection are only treasured and valued appropriately if they are also living in the same environment together with issues of freedom of speech. So, to make a long story short, I think my very first take on this matter is that I would love to live in a Turkey where a Ministry of Justice official is again sitting right next to me and ending with the same note that he has ended on the issue of data privacy. We have a lot to do, was the ending note. As we also have a lot to do in freedom of speech matters, and this balance should be stricken very carefully. I'm really very careful in not saying that Mustafa Bey would not say that, because I know that freedom of speech is also an important agenda item, but I'm trying to very forcefully make the point that the minute you lose the sight of the fact that these notions have to live together, there you may not have adequate equipment to deal with data privacy properly. So last word on it is trust, I believe, is a very tricky concept. I don't know that it means a lot when people are saying they have not built further trust on a concept like internet. I could ask the question of whether you have developed further trust with your neighbors in the recent while, and I don't think the answer would change either. One thing that should be noted is that information is increasing. I agree with what you said. The amount of information is increasing. The information is being generated because there is a free platform where that information can be changed. People think more because there are the likes of Google and Twitter. They think more. They produce more mental products because there are these platforms. And these are being made available more and more. And of course, with it, there are certain issues, but I think data privacy issues will always have to be balanced with freedom of speech issues for reasons we can discuss later on. But I wouldn't move from a concept of trust, because a concept of trust, I believe, does not have much to do with exchange of information, as information out there is very rarely secure anyway. Once it is made public, processing of it is a whole different concept. I have utter respect to the data privacy issues in total and everything that Giovanni has said, by the way. But I, for one, would vote that they be judged together with the principles of freedom of speech. Thank you.
Excellent, thank you very much. Giovanni, you set your stall out. Anything you very quickly want to add?
I'm ready to use myself. If you would like to know more about my story, I need to book a couple of hours to describe the fascinating experience I'm now doing. It's more than 2 decades, unfortunately, that as enforcer, member of the judiciary, professor, legislator, regulator, I have the opportunity to have a global overview. And let me say that I have concerns about some risks. First, that in a data-driven economy, in a moment where data is the oil of the society, issues concerning transparency, fairness, and trust, not speaking about protection of private life, are deeply underestimated by a lot of players. First. Second, I see big data out of the door, coming soon to change in depth the way in which we live, and the kind of consequences are deeply, profoundly underestimated. Third, I see the legislator everywhere thinking to the past rather than to the future by using too much traditional criteria, not necessarily, future-proof. I see people too much skeptical about the opportunities to have certain guarantees and safeguards in a balanced way. I see the risk, but I'm not pessimistic, but I see the risk that Council of Europe, OECD, European Union, United States, so big players around the world, continue to legislate in a non-interoperable way by not creating sufficient chemistry to make all these principles working together in a workable manner. In particular, the US Congress is reluctant under the Obama's mandate to legislate and transform into a reality the expected Bill of Rights, which was in a blueprint published January 2012. So these are the challenges, and I think that we need to have a debate.
We could debate. Excellent. Sophie, you were, as the head of Data Protection Council of Europe, there's a lack of chemistry. Do you lack chemistry in the Council of Europe?
Just read.
Just that.
Good morning, Mirella. I'm very pleased to be here. I want to thank the organizers, ISOC and ELIG University. Thank you very much. So about trust, I think I agree with the general trend that trust has been diminished in the internet, and that we need to work on it. And the question is why? What happened? Because Council of Europe, we have European Convention on Human Rights, we have Data Protection Convention, so at least in terms of law, we have a legal framework which is there. I think this question of making sure that we have a law which is time-proof is important. I would underline that the Convention of the Council of Europe on Data Protection that was mentioned this morning is definitely a good proof of the fact that you can have legal provisions that stand the test of time. They were general enough, they were visionary enough, so that today, over 30 years later, they are still fully relevant, fully applied, fully interesting countries around the world. I will underline that for our 47 member states in the Council of Europe, Turkey being one of them, Turkey is one of the sole countries that has not ratified the convention. This is a singularity. Not all singularities are positive. I think this is a pity.
and I really hope that the national data protection law will be enacted quickly. It's really vital. It's vital for Turkish people. It's vital at a global level. So I would only urge some progress in that respect. Myself, I was here in 2011 for a huge conference of ministers of justice. Your Minister of Justice took the commitment in a resolution to work on that, and we're some years later, the law hasn't been enacted. I think this internet governance discussion context, the fact that Turkey is hosting the IGF in September, should really give you some weight to get this law passed. It's important for the global exchanges. We have problems of trust, I think, in two respects. Surveillance, we mentioned it, so it's more national security, law enforcement, but also big data, private sector, how data move from one sector to the other, and this needs to be addressed. We have the law, we need to make the law better. I think at least in the Council of Europe, we're very aware of the fact that we precisely need to do something that is compatible with other frameworks. One big added value we have with our convention is that it's open, it's the sole legally binding instrument in the field, and it's open to any country in the world. So we have this potential to bring countries from all regions of the world to a common understanding. And we're trying to make sure that the language of this convention enables to do so, and is compatible with what the OECD is doing, with what the AFEC is doing, and of course what the EU is doing. This is vital for us. So that's the first take on the issues.
Excellent. Well, thank you very much indeed. It's just when I was doing some research for this, and I found two quotations, or actually three, that I think set things up quite nicely. And they actually tie in, Sophie, with what you were saying there about issues of national security and also issues of big data. And obviously, the national security one comes with post-Snowden revelations. And this is what Neelie Kroes, the Vice President of the European Commission and Commissioner for the Digital Agenda, had to say. She said, even when the phone of the German Chancellor is not sacred, that trust, which she's talking about trust, can never again be taken for granted. Not only that, but if it is clear for millions of Germans and billions around the world, so it is clear for millions of Germans and billions around the world that trust is now missing. And then, being the good bureaucrat that she is, and using Rahm Emanuel's great quote of never let a good crisis go to waste, her answer to this problem was a voluntary approach to data responsibility is not enough anymore. So she rushes, the first thing that she does is rush to bureaucracy. And that's a point that was picked up by Viviane Reding, who's also a Vice President of the European Commission, who said, I think somewhat cynically, said, thank you, America, for PRISM, which has helped us to make a very strong data protection law in Europe. So there we have two bureaucrats, two lawmakers whose solution to the problem is bureaucratic, is rushing to law, is a top-down approach. I want to flip and then just say one other thing about the big data aspect, and a very nice quote from a US professor, who I think is in a slightly different view, equally cynical. By 2025, says Professor Peter Jackman, I don't know who he is, a professor at the San Diego College, he says, by 2025, we will long ago have given up our privacy. The Internet of Things will demand, and we will give up willingly, our souls. We'll give up our souls. So we have two different issues there. One says, why are we all worried? We're going to do this anyway. It's in our benefits. If we want these new technologies, there's a price. And the price is those things that we willingly give up. And the other is the solution from lawmakers, which is, no, this isn't good enough, a voluntary approach isn't good enough, we need to legislate. Do we need to legislate? Do we need more law? Giovanni, as responsible for making law, or advising on it, why do we need more?
when I started my legal studies, when I became a member of the judiciary in the country, I started from a conclusion. At the very end, someone could be, I mean, an administrative body, could be a member of the judiciary, could be, I mean, a company in charge of something. At the very end, you will apply a rule. It could be a primary, secondary rule, something you deduct in terms of interpretation, or which appears clearly somewhere, but the rule is needed. So, question is where the rule is, how much soft is. Is the rule coming from a top-down approach? Stakeholders, and internet is an area where stakeholders are very well considered. So I'm not against rules, provided they, particularly around the issue of information technologies, they are workable and they give solutions. This is why, in advising the European Union, but also third countries approaching to this issue, I'm back from a mission in Japan, and Japan is going to legislate on data protection. And I said, do not make a copy and paste of the European Union approach at any cost, because you would like to achieve a license in terms of adequacy. You should also respect your own tradition, but try to think in a global terms and do not enter into too much details. Sophie was right by saying that the Convention 108 is still valid since it was conceived in a long-term perspective. So the question is, which kind of rules you would like to introduce? How much space you leave for soft guidance by involving also controllers, by involving enforcement bodies. So that's the conclusion.
Anyone else got a comment on that? Do we need more laws? Do we not get into this problem? Because we've seen government agencies, government bodies, particularly, you know, the US National Security Agency. But let's not kid ourselves that it's only the Americans who've been doing this. Has that caused one of the problems? So in other words, does the problem lie in too much government? And organizations like the Internet Society, stakeholder bodies, bottom-up approaches have been very successful in this area. Why would they not be successful here? Do we need more top-down legislation?
I, for one, would think, well, first, what I don't know. What I don't know is that whatever problems there are today may not be a byproduct of there being, you know, government intervention or too much law. That part I don't know. But the part I know is that in the market for ideas, it is very difficult to do good with more regulation. It's not me talking here. It's John Stuart Mills. It's Ronald Coase. It is Calabresi and Melamed. Whoever you consult on the law and economics of freedom of speech. And I don't want to be the crazy freedom of speech guy of this panel. But I think what I'm trying to say is it's such a tender area, such a delicate area, that by way of coming up with top-down approaches, you could be breaking more than you're fixing, and you may not even know about it. Whereas bottom-up approaches are always inviting as there is a need. So I think rather than governmental approaches and rather than the type of urgency feelings that clearly are demonstrated by Neelie Kroes, I would make a case that it shouldn't be the position of a bureaucrat or a lawmaker to say, clearly the non-governmental institutions are not enough. We should now be a participant in this ballgame. I think it is proven that it is working, but there will be road accidents while you're moving forward, and creating flags out of it, and just saying, oh, there has been Snowden, so now, we can't trust anything, or saying even the German Chancellor is being wiretapped, so I don't feel secure anymore, therefore we have to intervene. That's very dangerous stuff. I would, in a country like Turkey, it is extremely dangerous. But in any civil country, it is very dangerous for other reasons. I would therefore say that the road accidents should be ways of accumulating further experience and knowledge as to how you can prevent that, but not reasons as to why there should be broader principles that further governmental intervention is necessary. I think that's too big a sentence to come up with on the basis of a specific experience.
Okay, anyone, anything to add to that? Mustafa, I'm looking at you, and we're going to answer that question. Do we need more legislation? You are in the process of drafting legislation. Do we need more? Or should you actually just not bother and let civil society solve problems?
Aslında çok memnun oluruz eğer sivil toplum bu sorunu çözebilirse, bizi çok büyük bir yükten de kurtarmış olur. Fakat bunu temenni etmekle beraber çok gerçekçi olmadığı kanaatindeyim. Elbette sivil toplumun, üniversitelerin katkıları olacaktır, yönlendirmeleri, önerileri olacaktır. Fakat modern toplumlarda bu tür kurallara mutlak surette ihtiyaç olduğu kanaatindeyim. Elbette bu kuralların çerçevesi çok katı olmamalı. Bugün için çok uygun gördüğümüz şey yarın elimizi kolumuzu bağlayan bir noktaya getirmemeli. İfade özgürlüğünü yerle bir etmemeli. Ancak açıkçası şu an geldiğimiz nokta itibariyle bir normdan, bir yasak kuralından başka bu alanı düzenleme imkanımızın çok güçlü olmadığı kanaatindeyim. Şöyle düşünün, bir 100 yıl geriye gidelim. Arabalar yeni icat ediliyor. Trafik kuralı diye bir şey yok. Hız kuralları diye bir şey yok. Radar diye bir şey yok. Ancak arabalar sayısı arttıkça, kullanımları yaygınlaştıkça bir süre sonra ister istemez şoförler kendiliğinden şu kurallara biz uyalım, şu hızı geçmeyelim demediler. Yani insan doğası buna çok uygun değil. Mutlaka bir otoritenin el birliğiyle herkes için en uygun, optimum dengeleri içeren bazı kuralları koyması gerekiyor ve insanların da bunlara uyması gerekiyor. Şimdi geldiğimiz noktada kişisel veriler konusu hele internet ve bilişim teknolojisiyle beraber inanılmaz bir noktaya geldi. Hem kamu sektörü bu verileri alıyor, kullanıyor, işliyor, aktarıyor, paylaşıyor, hem özel sektör. Böyle bir alanın denetimsiz bırakılması, tamamen oluruna bırakılması, adeta suyun kendi kanalını bulmasını beklememiz açıkçası çok büyük hak kayıplarına, çok büyük mağduriyetlere yol açacağı kanaatindeyim. Mutlaka bu alanın üst normlarla, yasalarla düzenlenmesi gerekiyor. Fakat bunu yaparken bu yasaların hangi ilkeleri içermesi, nasıl olması gerektiğini tartışabiliriz. Elbette esneklik son derece önemli, soyutluluk son derece önemli. Çok detaylara boğarak yarın bir takım açılımlara engel teşkil etmeyecek normları düzenlemek durumundayız. Çerçeve normlar olmalı bunlar belki. Sophie çok güzel bir noktaya değindi. 1980 veya 81 tarihli sanıyorum 108 sayılı sözleşme. Ama bugün hala aradan 34 yıl geçmiş olmasına rağmen bizler için bir referans kaynağı olabiliyor. Pek çok ülke anayasasına baktığımızda bugün 100 yıl öncesinde ortaya konulmuş temel prensipleri biz hala bazı alanlarda referans alabiliyoruz. Dolayısıyla ortak aklı harekete geçirebilirsek 50 yıl sonra da işimize yarayacak, bize ilham verecek, referans olabilecek kuralları bugünden koyabiliriz. Dahası bence en önemlisi bütün ülkelerin parlamentoları hiçbir zaman devre dışı bırakılmıyor. Her ülkenin parlamentosu her dönem için çalışır vaziyette. Niçin var? Niçin biz bu parlamentoları koruyoruz? Güncel ihtiyaçları çözsünler, revizyonlar yapsınlar, update etsinler düşüncesiyle parlamentolar görevlerinin başında. Dolayısıyla bir yasa mutlaka olmalı. Az önce saydığım standartlar, belki yeni ilkeler, yeni standartlar da eklenebilir. Hepsini saymış olmam mümkün değil. Bunları içermeli. Ancak 5 yıl sonra baktık ki bazı ihtiyaçlara cevap vermiyor. Bunu giderecek revizyonlar yapmak zorundayız diye düşünüyorum.
Interesting. You talked about drivers. Has anyone here ever, who's been to Beirut? Anyone been to Beirut or Cairo? Anyone been to Cairo? Okay. Great, Beirut, maybe more so than Cairo. Cairo seems worse. It's a great example. You talk about traffic. As far as I can see, there are no rules in driving in traffic in Beirut. The man or woman whose job it is to paint the lines on the road, what's the point? Everyone just drives everywhere they go. Traffic lights are just nice things for people to look at. No one pays any attention to them. Yet the traffic flows. And you know the only time the traffic locks up is when the police come along and try and control the traffic, and then you're left out. So I'm not so sure, actually, on that one. Do you mind?
If I may, okay. I come from a country where rules about streets how to drive are simply suggestions. So let me jump in on your debate. But I have a question in return to you. How to introduce trust without any kind of soft or hard rules? I think that in front of surveillance programs and in front of profiling activities by business companies, the main concern of users and consumers is transparency. So what happened in NSA and what is happening around apparently free of charge apps and the mobile devices we all use with the same platform, so that's a problem for all. Is that the way in which we are profiled, segmented. I mean, before approaching privacy, before speaking about interference on our private life, because perhaps they simply collect information, analyze them, and they do not disclose the information, then there is apparently no harm. But it's unfair against, in front of everybody. I think that the evolution of the information society, the big data society, could be only successful if there is at least transparency. I would like to be informed about the uses of data. Who is using my data first? How I can, when necessary, rectify the information, or in any case, be aware of what I'm doing in providing certain information. And in front of, serious ethical issues, such as the right to oblivion, we should not be irritated by certain, decisions. For instance, the one from the European Court of Justice, which is not entirely new. The right to oblivion already exists in many countries. And I think it's not freedom of expression. I'm coming from Athens, and yesterday Peter Fleischer, Senior Privacy Counselor of Google, tried to speak about freedom of expression. I say, be prudent, because it's a search engine. It is more business than First Amendment in the US. Question is that the data protection rules around the world protect individuals with regard to any kind of fundamental right, not only privacy and data protection, including the right to personal identity. We are not identical for all our life. We grow, we have different identities, we have a right to have, objectively speaking, a new identity. So question is to see the key role of a search engine is the right to the personal identity respected where, I mean, everything I did in my life is publicly available to all through a search engine? You may say yes or not, depending on your view. But perhaps there are some adjustments. You may encourage publishers to use devices such as robot.txt's tools. To have a proportionate approach. So the question is not the principle as such, but the way in which this principle coming from the Court of Justice will be now implemented. I'm sure Google will be bombarded now by thousands of requests. The question is in which workable and proportionate way they will start implementing this. The more proactive they are now, the more the legislator will be distant from introducing the rules.
Okay, so we seem to have reached trying to bring some conclusions, or not conclusions, but gather things up. We seem to be suggesting that in order to come back to the question of rebuilding trust, no one is suggesting an anarchy. No one is suggesting that we don't need rules. There seems some debate about should the rules be generated top-down? Do we need, or should they be bottom-up, stakeholder, civil society? And I suspect, as with all these things, at least somewhere in the middle. So a rules-based system seems to be one of the things we've been talking about rebuilding trust. So Giovanni, let's move on to what you've been talking about there, and that's transparency. The elements of transparency and how important that is for trust. I was looking at some research on this, and there was some research by one of the UK firms of analysts, Deloitte, surveyed British consumers, and 70% of UK consumers said that a reason for them to break off their relationship with any commercial organization was fear that they would misuse their data. They didn't know what was going on. That was more 50%. This is quite interesting. 50%, only 50% said that if they were paying too much. So if you're a company, as long as you can charge people what you like, as long as you tell them what you're doing, they seem very happy. So transparency seems to be quite a key issue. But Giovanni, you also talk about the European Court ruling. Do people know about what this right to be forgotten ruling? Are people familiar with that? There was a ruling very recently involving a guy in Spain, and the European Court said Google had to remove references. It was to do with rent, I think. Yeah, property.
Property being sold because of
tax. That's right.
That's.
So he's actually managed to achieve the fact that only people in Spain knowing about his property deals. He's now actually a global figure and everyone knows about his property deals. So I'm not entirely certain that's worked out for him. But do we have a conflict here then between transparency on the one hand and on the other hand a person's individual right, which Vivian Redding has been very keen to promote, this right to be forgotten? That's the very opposite of transparency. I'm going to know less about people rather than more about them. And we could end up in a very strange situation where members of the European Union, citizens of the European Union, will know less about their fellow citizens than non-citizens of the European Union. Because for Google to implement this, or any search engine, Google, Bing, you're going to look at where did the request come from? Did it come from outside the European Union? Fine, then I don't need to worry about it. Did it come from inside the European Union? Right, so I cannot provide this information. So I could be in Thailand and know more about you or me than we know about each other. So is that a way to build trust in a system? Or are we actually working against ourselves? I'm not going to ask you to answer that, Giovanni, because you've answered lots. Who wants to pick that question up?
Freedom of expression and the right to privacy. And I just want to highlight that this ruling of the court indeed is recent, but there's nothing new about that. And at least there it's completely in line with what the Strasbourg Court, the court of the European Convention on Human Rights, has been doing for decades, balancing private life and freedom of expression on the other hand. And we have defined some criteria in the case law, and things are pretty clear. Here, what is new definitely is internet age and trying to translate this, the principle on the balancing act, in an internet environment with the broad dissemination of information. So that's one point. The other point I want to make, we speak about right to be forgotten, which indeed was a marketing term with the proposal for the new regulation. There again, we need to highlight it's not new. We have a right to have our data deleted, and this is something we already have in the Council of Europe Convention, which dates back from over 30 years ago. We have the right to have the data kept by the processor for no longer than is necessary. So this is also an aspect that contributes to it. All those put together brings this right that the court has tried to impose. And definitely our societies need to be able to forget about things we've done. My criminal conviction after some years could be deleted from my file. Why at internet age, if this is not in the file, somebody could still find a trace on the internet of this. There should be a way for me to be able to ask that this be deleted, definitely. So I think it's an important right, and I think it's important to enable users, data subjects, to make it effective in practice.
Okay.
I think this is a very sophisticated issue, again, because there are very many levels of it. For example, when you're running a search on a search engine, the fact that you're running a search is also data that you're submitting to the search engine. That is one layer of the data privacy issue. But then again, the results that are going to turn up is a whole different ballgame. And what makes this freedom of speech and the right to know matter is whether you're going to impose these liabilities on a search engine. So that's a whole different level of a ballgame, and we're not talking about what the court in Strasbourg was doing before. This is new, brand new, very new, and very dangerous too. And there will be views, such as my view, that the right to know is not properly balanced with the right to be forgotten. No one is saying the right to be forgotten is just hot air and should not be respected, but when you go for the concept of the right to be forgotten and impose it on a search engine, what you're doing is effectively hushing up certain content that is still there. That's very, very interesting. That is worth debating, because it is lawfully there. It's not like the example that was used where the records were cleaned and it should have been removed, but it is still there. What do I do about it? It is lawfully broadcasted by a newspaper, and that newspaper clipping of 16 years ago, admittedly a very long time in the Spanish case, is being looked at by a search engine, because when you run a search term, that's what the algorithm catches. Now the question is a question that I have time and time again trying to respond. In June 2010, I was in an international internet law conference saying search engines do not own internet, and liabilities on internet should not be lived through search engines. That's not a good way of governing. And in February 2013, when we published in the Computer Security and Law Journal the article called Understanding Search Engines, again, time and time again, what we were saying was that search engines find something that is already there. If it's not lawful, it should be removed from there. But if you were to go to that great distance of making the search engine liable from removing something, actually the search engines are going to become the polices of internet.
And bringing it back to the topic, does that rebuild trust? Do we feel that we have that if we make Google a corporation, a company incorporated in the United States, the guardians of, they are the people that get to say whether or not something is here, you know, we are allowed to know something or not. Do we feel that that increases trust in the system, or do we feel that that decreases trust?
That's a good question. I don't have the answer to that. That's the question.
Answer also, but new to this ruling of the court is that Google is actually a data controller in the eyes of European data protection regulators.
Yes.
So the way to find a solution in this kind of data protection issues is difficult, because if you are in the digital world, you have to catch someone, because there is no one who can, if you go down the layers to other contributors, you cannot reach them. But if you have one who is also spreading the whole information, there is an address you can connect with. And therefore, it is maybe right to urge search engines to build their own principles, or in order to protect data protection. But we have to ask further if it is the right solution to put the data protection principles onto the search engine. If it is really his or its burden to implement.
Yeah, great. Yeah.
In the US, Consumer Bill of Rights published a couple of years ago a text on which everybody in the US agreed, but which will not be approved for at least 2-3 years from now. It is saying that consumers should have the right to have the data processed in a way, I mean, compatible with his or her reasonable expectation about the use of the data. So not only transparency, but contextualization. This is something similar to the proportionality principle. So again, the issue is in between deletion of data and, I mean, publicly available information. There are different layers we need to consider, also with regard to the right to be forgotten. My grandfather was deported in Germany, in a Nazi camp, and I'm now approaching the state archives to, I mean, know more about his history for family reasons. Is someone familiar with Bad Arolsen, the Bad Arolsen Treaty? Bad Arolsen is a small city in Germany where a Nazi camp was established, but it's also a city where an international agreement was signed, because there is a museum and there are billions and billions of records about Nazis' horrible human test against deported people. Pictures, videos, documents, and then they decided a few years ago to put this document available for the 7-8 countries signing the agreement, but subject to the condition not to publish this data on the web. Israel started by saying, we would like to this data to publish on the web, because we would like also to approach the family victims, and therefore the discussion took place. Is this proportionate in the name of, I mean, the right to information? So perhaps what's important is to publish a notice to say all relatives, I mean, could approach this information and perhaps, I mean, have access to all relevant information, rather than simply posting all in the name of the right to inform people this information publicly. So accessibility, public availability is something to discuss at different layers.
Reasonable views. I feel like you're all sitting there and doing your on Twitter or doing your email. And I feel it's now time that we get you people to do some work. No one said this was going to be easy. So we have this fantastic panel here. The majority of you felt that that you had less trust in the internet. So you must have some questions as to how you ended up in that position. So I'm going to ask one more question, and then I'm going to come to you, and we're going to be looking for questions. So if you think, oh, I'm not going to go straight to a question, a much better idea. Can we get a microphone to this gentleman here, just behind you?
Thank you. Grigori Salyan, Armenia, Internet Society of Armenia. So the question is following. Are you seriously believe that it is possible to protect personal data in the internet? Seriously, not theoretically. Is it possible in real life?
Very good question. Great question. Is it possible to protect, on the internet, is it like seriously possible to protect your personal data? Who's going to pick up that one? Yeah, you answered the last question. I'm going to pass it. Who's going to do it? One of you has to do it, otherwise I'm going to pick someone.
Let me take a very quick stab.
Take a quick stab, and then Neil will be more
I will say the following, something that I have been saying for quite a long time now. I think in the area of technology in general, but especially in terms of internet, it is very difficult for legal texts to follow the developments. So I cherish the fact that we have discussed that rules need to be flexible, should it be bottom-up or top-down. These are very germane discussions, I believe. And coming to your question, I think that the main reason why it is very difficult to come up with really honestly protecting all data that should be considered as private data is because that concept is constantly reinventing itself. The data itself is being molded at the same time while the concept is being reinvented, and now the legal principles that were not previously applicable in a particular fashion are being applicable to this matter too. So I think what we can call it is there's a fudge, a whirl of moving targets in this area. In certain prongs of it, I think it can be successful, and regulating it is not a lost cause, especially in the particular matters Giovanni touched, like you submitting your data to the commercial company with a completely different purpose, but that commercial company also using it to categorize you and all that. I think there are certain goals to be attained there. But as far as the question goes into the question that was discussed as maybe I have done something 15 years ago and I don't want people to know about it now, how can I make sure that this happens? I think it's going to be increasingly more difficult. If I am broadcasting all these views right at this minute here in this conference, I am almost regulated intrinsically that 15 years from now I won't be able to depart from what I am saying here. And that's happening right now. It's already happening to me. And it was not happening to people 15 years ago, because they did not know that in 15 years' time, actually all of this was going to be available and people were going to remember. Admittedly, the decision of the court is saying that public figures and abundant public interest should allow for departures from the holding of the decision. So the court is dealing with this issue in its own way. But still, it's a huge problem, and I come back to your point there, that search engines should not be the judges of what is preponderant public interest, what is not preponderant public interest, and that's very dangerous, and it's very difficult to think that that would build a trust. That trust was not lost in the hands of search engines. If it was lost, it was lost through the information becoming available and suddenly turning the search engines into the police officers of that trust being rebuilt. I don't think that's going to serve the goal.
You want to pick that up?
I wasn't sure.
No, that's okay, don't worry.
Let me add only a few sentences. I would say briefly, of course, it is not possible to protect our personal data in the digital world from spreading around, but this is not, I think this should not prevent us to make attempts to protect our data. And therefore, it is important to really empowerment of citizens would be an important step to provide knowledge and information to data subjects in order to create a powerful area for them to protect themselves. Because if people know what is going to happen with their data, maybe they will decide better to spread the data or not. And we should start in a very early level. So I think data protection in schools would be one solution, or data protection for scholars and students. Right in the digital age, it would be a good step to start.
Excellent. Right, another question, or we're going to get talking about cricket. And believe me, that would be unbelievably boring. Lady here, over here, if you get a microphone.
Hi, additional to your comments, I would like to ask you how will be the trust between governments and the regulations, between regulations and the digital society. How we will build that trust?
Well, we'll just try and find out. Between governments, particularly.
Government and digital society.
So, is your question then about how do we trust
government,
the government to
and
do
regulations and laws?
Guess what I'm going to ask? For you. Yeah.
Az önceki konuşmayla bağlantılı olarak kısa ekleme yapmak istiyorum. İnterneti aslında bir havuz gibi düşünmemiz lazım bana göre. İnternete bir sürü verileri atıyoruz. O havuza atıldıktan sonra artık o verilerin güvenliğini sağlama, gizliliğini sağlama son derece zor, hatta belki imkansız. Ama önce nasıl hastalıkla mücadele ederken koruyucu hekimliğe ön plana çekiyoruz, hasta olmadan tedbirler almayı araştırıyoruz. Aynen bunun gibi hangi verilerin internet havuzuna döküleceğini, hangilerinin o havuza atılmaması gerektiğini, buna yönelik bir takım ilkeleri daha sağlam oturtmaya çalışmak lazım. İkinci husus, dünya insanlık tarihine baktığımızda inanılmaz süreçlerden geçti. Örneğin bir virüs, veba virüsü, on binlerce belki yüz binlerce insanı aldı götürdü. Ama insanoğlu kafa yordu ve mutlaka onun tedbirlerini buldu, önlemlerini aldı. Örneğin çevre kirliliği ile ilgili bir dönem inanılmaz bir akımla karşılaştı. Ama buna yönelik önlemleri de aldı. Ve tabirlerinde ise kontrol altına belki de almayı başardı. Aynen bunun gibi kesinlikle burada ümitsizliğe düşmemek lazım. İnternet ve özel hayat arasındaki o dengeyi sağlayacağımıza ben inanıyorum. İnsan beynine, insan aklına güveniyorum. İnanılmaz şeyler bulacağız ve buradaki dengeyi makul bir düzeye getireceğiz. Ama şunu bir kez daha vurgulamak istiyorum. İnternet havuzuna dökülen bilgileri korumaktan bizim vazgeçmemiz lazım. Yani sivrisinekle mücadele etmekten vazgeçip bataklığı kurutma mantığını burada devreye sokmak ve internete dökülen verilerin dökülmemesini hangilerinin dökülüp hangilerinin dökülmemesini analiz etmeye yoğunlaşmamız belki gerekiyor.
Excellent. Hang on one second, just 2 seconds. I just want to get it and want to come back on that, and then I'll come to you. Yeah. And I hope we do this. Yeah.
Again, I'd like to remind all of you that I'm speaking in an academic capacity. This is not Google or Twitter speak. I am extremely fearful of the last views that you have all heard, and that this will prevail in Turkey. I would think that the internet is not a pool and it's a flowing river, if anything. And more importantly, the minute governments try to determine what is going to go into the pool, we're not talking data privacy anymore. And data privacy is being used as an etiquette for doing something else. That's censorship. The pool that is internet should not be seen as a swamp, first of all, but more importantly, the information should really freely flow into that. What we were debating here until now was whether a data of 16 years old should still remain there or not, and the right to forget was being contrasted against the right to know, and whether the court decision has stricken the correct balance. That's a whole different ballgame. The minute you say, well, it's a pool, and I believe rather than dealing with the pool of internet, we should deal with what goes in there, it means I'm going to regulate what is being submitted into the internet, which has led to the anxieties that has led to some access ban decisions and some quite draconian remedies against internet companies, which was contrary to the spirit of internet and free speech to begin with, as the Turkish Constitutional Court has said too. So I would say that this is a good moment to take a minute and see that data privacy issues should always be seen in the technical sense that Giovanni was articulating, and not suddenly become measures of regulating internet beyond the spirit of internet, if you will. And this came right after a question of how do we trust governments in regulating it, and my response to it is this is why we need a bottom-up approach and not a top-down approach, because the governments are not prepared to take on this particular responsibility.
I mean, it's a great question. I'll give you a very good example, which completely surprised me. The country of Estonia. Anyone been to Estonia? Anyone been to Tallinn? Yeah, incredible place. In Tallinn, in Estonia, the government issues you with a smart card. And the government provides encryption services for you to encrypt data and digitally sign it. And I interviewed the president of Estonia about this, and it was I was absolutely amazed that the trust that the citizens have in their government, that they allow the government to do their encryption services. You try that in the UK. Like you go to the here's a card, and you use this, and it will encrypt all of your data, and we promise you we won't look at it. I mean, it's unbelievable. So it is certainly possible. Whether it's possible for anyone apart from Estonia, I have no idea. I'm sure as hell it couldn't work in the UK, that's for certain. So it is possible. I think it comes down to what your trust is in your government. Do you, at the end of the day, trust your government? And most governments, there's pretty good reason why you should be skeptical. Let's put it that way. Politely, you should ask serious questions of your government. Right, another question. Gentleman at the front, hands straight up. And then we're running technically into lunch, but I've been allowed to overrun a little bit, and then there's a question somewhere around there. So we'll come to that one. Gentleman at the front.
My question is, I think there's some, or I don't understand, what is this personal data? I think there is some kind of definition differences in the participants or the people who are talking. What's for Mustafa Bey and what's for Giovanni is kind of different because, for example, now I am talking. My view is this my data or is this your data as well because I'm talking to you. I don't, and I agree with Gonenc that the internet is could not be a place where personal data islands has to be separate from each other. Internet is a network that makes or tries to make in the naive way one knowledge by combination of. So that's why we are providing data. And
great question. Great question. What is
if I have one more
quickly, just
half a minute. This is, for example, in Turkish the judgment system is used for Google is used for providing what's called as a supporting tool that there's something going wrong in one of the examinations because so many people search through Google engine for something else. So
I want to pick that up because I want to get another question. What is personal data? That's a really, really good question. We should address that. Why did it start? Who wants to pick that up? Giovanni, you jumped straight in there.
Simple to answer. I didn't notice any disagreement. And frankly speaking, I also know the correspondence in the amendments commented this morning. Personal data is not something to analyze in terms of ownership. It's any information relating to an identifier, to an individual. In countries where all individuals are protected, there are a few countries where all legal persons are protected as well, not only in terms of industrial or company secrecies. Relating to means that you should simply analyze the link in between a piece of information, regardless of the added value it has, and a physical person. It could be your plate. It could be certainly, in a lot of cases, not necessarily in 100%, your IP address, traffic data, log files, and in future, in the Internet of Things, all kind of sources are to be considered, which will be relevant to say where you are, or what you are doing, what are your preferences, what about your behavior. Then a subcategory of personal data is to be considered as sensitive because they relate to, your health, sexual life, political belief, and perhaps in this case some additional safeguards are required. Moreover, another subcategory of information is considered in terms of prior checking, where depending on the modalities of the processing, the nature of the data, the context where they are used, there are additional risks to be considered. But it's a broad notion. It's open to developments, and perhaps one of the few notions, starting from the potential 108, which is stable in this area.
Great. We have time for one more question. It's all between us and lunch. So, lady here. Nice try, sorry.
My question is for Gonenc Bey. He has been emphasizing the importance of bottom-up approach for data protection legislation making. But in EU, as we have been talking about, there are many directives for data protection, and as far as I know, they are not soft regulations. So we see an example for top-down approach here, I think. So can he make it clear what he means by bottom-up approach for data protection regulation? Thank you.
Very specific.
I wouldn't say that the approach has not been bottom-up in the EU or in the UK. I think there are enough NGOs dealing with these issues. There is enough self-regulation. Well, enough. I don't know if it's enough, but there's a lot of NGOs dealing with these issues and a lot of self-regulation going on. In my vocabulary, when I say top-down, it is that the state takes the ball, picks it, and runs with it, and people are trying to follow what is going on. That is very frequently the story in Turkey. And that's not necessarily always the fault of the state, because the NGOs may not be doing a very, very good job either, as Mustafa Bey was saying. Well, we would be glad to see NGO contribution. It's just not that we're not getting a lot of it. So to make a long story short, I think bottom-up approach is going to mean that we're going to see the need first, the inability of the stakeholders on a voluntary basis, and that intervention becoming insufficient so clearly that that approach is sometimes, from time to time, supported by state action too. But I would always make a case that incidents such as the Snowden incident, such as the German Chancellor's situation, should not lead to the type of quotes that are given by Emilia Cruz. Because that's a change in paradigm, that's a change in principle. It says, we have seen that this did not work, so when this doesn't work, we know what to do, we interfere. I don't think that's going to sit well with the nature of internet. So always in moderation, I think.
Mustafa, you wanted to come back on that? And you have the last one.
Ekleme yapmak istiyorum izniniz olursa. Öncelikle kişisel verilerin içeriği bakımından Sayın Giovanni ile farklı düşünmüyoruz. Aynı şeyden bahsediyoruz. Öte yandan internet ve bataklık kelimesiyle Gonenc Bey öyle anılmak istemem açıkçası. Bir kasıtlaşan ifade veya bir farklı algılama oldu. Orada mücadele yöntemiyle ilgili ben bataklık kelimesini kullandım. Yani sivrisinekle mücadele etmektense bataklığı kurutmak diye bir atasözümüz var. Bunu kullandım. Yoksa interneti bataklıkla yan yana getirmek istemem. Öte yandan kastım belki de şuydu, iyi anlatamamış da olabilirim. İnternet havuzuna atılacak bilgilerle ilgili iki tane kaynak var. Birisi benim kendim. Ben burada çekilen resimlerimi internette paylaşabilirim, Facebook'ta paylaşabilirim, Twitter'da paylaşabilirim. Bazı görüşlerimi, siyasi düşüncelerimi, mezhebimi, inancımı paylaşabilirim. Ve bunları kendi irademle, rızamla internet ortamına koyabilirim. Bunların unutulma hakkı ayrı bir konu. Ve buraya koyduktan sonra bunun erişimini engellemek, güvenliğini sağlamak son derece zor. Fakat benim iradem dışında polisteki bazı kayıtların internete sızdırılması, sağlık tesislerindeki, hastanelerdeki bazı verilerin internete sızdırılması, benim iradem dışında bunların önlenmesine yönelik bir takım tedbirler alabiliriz. Kastım bu. Oraya yoğunlaşmalıyız. Demek istediğim bu. Nitekim hem sözleşmede hem direktifte buna ilişkin yaptırımlar getirilmesi öngörülüyor. Kişisel verilerin paylaşılması ve aktarılmasına ilişkin bir takım kısıtlamalar getiriyoruz. Niçin getiriyoruz? O internet havuzuna onlar düşmesin. Yetkisiz üçüncü kişilerin eline geçmesin diye. Kastım buydu benim. Yani veriler arasında belki bir sınıflandırma yapıp bazı verilerin kamuoyuna yansıması, internet ortamına düşmesi, üçüncü kişilerin eline geçmesini önlemeye yönelik daha sıkı tedbirler alabiliriz. Kastım buydu. Yanlış anlaşıldıysa kusura bakmayın da düzeltmek istedim. Saygılar sunuyorum.
Excellent. Thank you. Unfortunately, we've run out of time. What? All right. Okay. It has to be really, really quick. It's you or lunch, and we're going with you.
Thank you. So my question will be about our new regulations and laws in Turkey. As you know, we are going to have a data protection authority in Turkey, and this will be attached to the ministry directly. So do you think this structure will get clearance from the European Union? And a little bit comments about that.
Who wants to take that one up? Do you want to do it yourself or? So we're getting you, or do you want? Giovanni, you want? Okay, you talk about Turkey, you talk about European Union.
Şu an taslak Başbakanlıkta. Bakanlar Kurulu imzasında açılmış vaziyette, onu bekliyoruz. Umuyorum kısa bir süre sonra Türkiye Büyük Millet Meclisi'ne gönderilecek. Veri Koruma Kurumu ile ilgili Avrupa normlarının farkındayız. Bağımsız çalışması gerektiğini, farklı kaynaklardan gelebilmeleri, kararlarını özgürce verebilmeleri, bu konuda hiçbir tereddütümüz yok. Son derece mutabık haldeyiz. Fakat siyasi iradenin de kendi düşüncelerine göre bir takım talepleri var. Dolayısıyla bu konuda açıkçası hukuki görüşüm benim net. Fakat ben karar vermiyorum. Dolayısıyla nasıl bir veri koruma kurumu çıkar, henüz hala netleşmiş değil. Gelgitler yaşanıyor. Fakat burada şöyle bir tercihte bulunmamız gerekiyor. Biz siyasi iradeyi doğru bilgilendirme adına şunları söyledik. Dedik ki biz 30 yıldır veri koruma alanında güvensiz ülke konumundayız. Bundan sıyrılmamız lazım. Bir an önce bu yasayı çıkartmamız lazım ve bağımsız bir kurum oluşturmamız lazım. Fakat bağımsız kurum konusunda bazı tereddütler olduğunu görünce ya bu yasayı komple rafa kaldırıp buzdolabına kaldırmak, tercihlerden birisi buydu, veya veri koruma kurumu ile ilgili bazı eksiklerimize rağmen bu şekilde yola çıkalım. Maddi hukuk boyutu ile ilgili de süreç içerisinde eksiklerimiz mutlaka çıkacak. 2015'te direktif güncellenecek, sözleşmede yenileme çalışmaları var. Onlarla beraber bir sonraki revizyonda en kötü ihtimal böyle bir düzenleme yaparız diye düşündük. Dahası Avrupa Birliği organları kurulların, bu tür kurulların bağımsız çalışabildiğini görmesi halinde yasadaki bazı eksiklikleri çok dikkate alıyorlar. Önemli olan onlar bakımından işlevin bağımsız şekilde yürütülebilmesi. Umuyoruz ki kurulan veri koruma kurumu bağımsız bir şekilde çalışmalarını yapabilecek bir yapıda olur diye umut ederim.
Excellent. You have the last word.
Oh, thanks. Use it wisely. Independence is not only, ability to act without, taking on board instructions or interferences by others. It's a living notion, and you may pay attention to three decisions from the European Court of Justice concerning Germany, Austria, and Hungary. These three countries have been condemned by the court for the lack of independence concerning certain adjustments. So additional elements you will find not only in the draft regulation but also in the Article 29 working parties decisions concerning the adequacy findings of third countries. So anytime a third country, compared to the European Union, would like to be better in touch with the European Union in terms of adequacy, an assessment is made with regard to adequacy. And for instance, I noted some elements in the text shown this morning, very similar to a situation in Argentina, which was criticized some years ago. So I would encourage, again, I'm not interfering in internal cuisine in Turkey. I very much appreciate what Mustafa said by highlighting the demands of politicians and governments. But I would like to encourage you to think again in a global term, by also paying attention to what the Council of Europe is doing now in terms of modernization of Convention 108.
And that's it. The question or the topic we were asked to debate was about rebuilding trust, and it seems the conclusion, if we can draw one from all of that, is we need a regime, a structure that is rules-based. No one is suggesting, fortunately, we don't have any anarchists amongst us suggesting modelling our internet on the Beirut traffic system. I think that's me that did that. It needs to be rules-based, but those rules, the suggestion, it seems to be that we have to have a system that allows civil society to have its voice. It can't be a top-down imposition. It seems that the view is that we want civil society and the broader public to be involved in it, and transparency seems to be at the heart of this. There was some debate about, I'm not sure we reached a conclusion on, if it were possible to reach a conclusion, on the opposition between the right to be forgotten and the freedom of speech. And those two things seem to be possibly in contradiction. And I'm not sure we reached a conclusion on that. It would have been amazing if we had. On that note, I'd like to thank this fantastic panel. I think they deserve a huge round of applause for their contribution. And I invite you all to lunch. Actually, I'm going to invite you all to listen to Frederick. He's going to
No, you're right. I was just about to say that. I know it's a shame to interrupt this wonderful panel for just a lunch, but here we are. Housekeeping again. Just 1 hour, no more, please. So 2:15, we will come back here and listen hopefully to my colleague Marcus Kummer on the governance and politics. So be here 1 hour starting now. Thank you.